can't longer people wanted to now on the focus. Yeah. Okay. Well, welcome everybody both here and in webinar land. And my name is Ron Zeback, chair of the Death Penalty Committee of the section of civil rights and social justice. And I will give very brief biographical information about our panelists, and I'll give a little bit of an introduction to the origin of this program. I almost said Genesis, but I don't want to in the session. The first thing was they're going to be speaking in order, and then you may have some invitation. I may ask a question. They're not going to be media questions asked during the program or afterwards. First to speak will be Karen Valley, who's the co-director of the Florida Center for Capital Representation. Those who I think have access to these remain online. Extensive experience in litigation in Florida, and winner of many awards, as is Meredith Martin Roundtree, who is the senior lecturer at the Northwestern Pritzker School of Law, and extensive experience in Florida. I'm sorry, Texas, at the University of Texas School of Law, Capital Punishment Center. Third will be Rob Sutton, who has spent many years, first in a private law firm in Oklahoma, and then otherwise working in Pennsylvania on death penalty cases, and is now the executive director of the Death Penalty Information Center, which, even if I weren't on the board of directors, I would say is the best source of information on death penalty. And last but definitely not least is Cardinal Blaise Supich of the Archdiocese of Chicago, and he has a stellar background as anybody who gets to the position he's now in. We'll do why later on the program. Now, the genesis of this program was when I read last October the Pope's statement about the death penalty, in which it was sort of startled to me the parallels between the legal doctrine of evolving standards of decency and how the law is not tied down for those who follow that the Constitution. And as we learn more, and as the public is involved, it can change over time. And the topic of the Pope's talk was that the Church's teachings are not orthodox, that regardless of what the Church learns and experiences, that it will always adhere to the same teachings regardless of what's going on in the world. He used the death penalty as an example. So it occurred to me that it would be an interesting program to start by talking about how the death penalty actually has functioned in the United States in various contexts, in various efforts trying to be made to make it fair and accurate. What's happened to those over time, what we are doing now, and then turn it over to the Cardinal to give whatever he wishes to talk about the Church's perspective on the subject, and then we'll proceed from there. I do find that it is the most interesting subject, could not be more timely, and I think we will start off with our first speaker, Karen, telling us about some of the guiding principles that led the Supreme Court to bring back the death penalty as constitutional in the 1970s after first taking everybody off of death row.
Well, I think any discussion of the modern death penalty has to start 1 year before the Supreme Court did just that. In 1971, the Supreme Court decided the case McGaugh versus California. California had a unified trial. In other words, the jury decided guilt innocence and decided whether to grant mercy or not without any standards. And so the question for the court was whether that violated due process. And the majority held that it did not. And there was a strong dissent holding the opposite by Justice Douglas, Marshall, and Brennan. And the language of the court is rather ironic when we turn to today's death penalty. So I wanted to start there. What the court said in McGaugh is, this is the majority, to identify before the fact those characteristics of criminal homicides and their perpetrators which call for the death penalty, and to express these characteristics in language which can be fairly understood and applied by the sentencing authority, appear to be tasks which are beyond present human ability. So 1971 is beyond present human ability to have any kind of fixed standards. And so the due process argument of the prisoner was rejected. 1 year later, 1972, the court was decided Furman versus Georgia, and decided under the Eighth Amendment that the majority decided the death penalty as applied violated the Eighth Amendment, the cruel and unusual punishment clause. The decision in Furman was really very confusing, I think, to the legislators. We had 9 separate opinions from the court. And I don't have time to go into all of the separate opinions, but I did want to mention what Justice Marshall said in his concurring, because he identified some of the problems with the death penalty that are particularly poignant and relevant today. He pointed out that the death penalty is not more effective a deterrent than life imprisonment. And let me back up. He pointed these problems with the death penalty, saying that if the public knew what the death penalty was all about, if they understood the reality of the death penalty, they would never favor the death penalty. And then he went on to make these points. So it's not more effective a deterrent. Convicted murderers are rarely executed, and usually their sentence turns into a long prison term. Cost of executing the prisoner exceeds the cost of imprisoning the prisoner for life. And the death penalty process does not choose likely recidivists for execution and may actually stimulate criminal activity. And later we are going to talk a little bit about so-called volunteers for the death penalty. So the Furman dissenters said essentially, this is a decision that the legislators make. This is not for the courts. Separation of powers, federalism, interests in terms of not being judicial activists, really precluded what the court was doing under the Eighth Amendment. And a historic analysis of the Eighth Amendment as well indicated that the death penalty was certainly not what was in the framers' mind when they enacted the cruel and unusual punishment. So the bottom line, though, was legislators were really torn between what do we do? The death penalty was stricken across the country. Everyone on death row was commuted to life sentences. And I think at the time, everyone thought that there was a good chance that there was not going to be a death penalty. I've read that at least the justices thought that. At the time of Furman, 41 states, the District of Columbia, and many federal jurisdictions had the death penalty. By 1976, though, 4 years after Furman, 35 states had reenacted the death penalty. My home state of Florida was the first to enact the death penalty. They waited just a couple of months. And in 1976, the U.S. Supreme Court again considered the constitutionality of the death penalty, and in 5 decisions held that the 3 states that had essentially standards and a strong role for the jury were consistent with the 8th Amendment. 2 states that had a mandatory death penalty system were not. That there was a requirement that there be consideration of mitigation and individualized sentencing. At that point, well, let me back up to the goals that the majority pointed out in Gray that the death penalty served. So the first goal mentioned was retribution, and although the majority didn't want to key on vengeance, they did note that having a death penalty would avoid lynching, would avoid vigilante justice, and so there was a reason in terms of retribution. They addressed deterrence and said, well, the case is not really clear on deterrence, but they certainly conceded that that's probably a deterrence. Not clear. But they certainly know that the death penalty would incapacitate the prisoner who was sentenced to death. And they went on to hold that the death penalty was not disproportionate to murder. They only addressed homicides. In terms of proportionality, the court in later years would use the 8th Amendment proportionality analysis to key in on the offender and on the offense. And in terms of the offense, the court rejected the death penalty for rape of an adult. Years later, for rape of a child. They rejected the death penalty if the defendant was convicted just of felony murder and could not be shown to have been a major participant with reckless disregard of the consequences. So unless the state could show that, the death penalty was precluded. In terms of the offender, they held that gradually, after some children were executed, that the death penalty could not be imposed on a child under the age of 18. They held that the death penalty could not be actually executed on someone who was insane. They held that the death penalty, finally, could not be imposed on someone who suffered from intellectual disabilities. The next question that we're litigating is whether you can have a death penalty for those who are seriously mentally ill. I think we're going to talk about that a little bit later on. One focus of the courts throughout the death penalty history has been on racism and the problems with race and the death penalty. In 1987, the court had the opportunity to really look at statistics. There was an amazingly comprehensive study done by Baldus, and the court had to look at all of these criteria that he classified and did regression analysis. And they looked at all these characteristics and concluded that a defendant killing a white victim was 4.3 times more likely to get a death sentence than a defendant who killed a white victim. And looking at the characteristics of McCleskey, he determined that 6 out of 10 prisoners, like McCleskey, would not have gotten a death sentence. These are death sentence individuals, would not have gotten a death sentence if in fact their victim had been Black. So this amazingly comprehensive study was presented to the Supreme Court. And the court, I think, had a very hard time with it. But what the majority said in rejecting the Eighth Amendment and equal protection claims of the prisoners was, at most of all, the study indicates a discrepancy that appears to correlate with race. A discrepancy that appears to correlate with race. Well, the dissenters have underscored what a amazing study Aldous had done, and how the statistics didn't lie. There was really no way to refute what Aldous was able to show. But McCleskey, 5-4 decision, rejected the study on race. And that is a problem that we continue to see today when we look at our statistics. More than the race of the defendant, although that does come into play, the race of the victim is probably the most significant indicator in terms of whether the prosecutor is going to seek the death penalty and whether the defendant is going to get the death penalty. To illustrate the arbitrariness that we see throughout the U.S. Supreme Court decisions, we can't have standards. Well, now we have standards, and those standards were approved in terms of the Georgia, Florida, and Texas system. To later challenges to what do those standards mean. Certain aggravating factors were found to be vague and overbroad, and they've now been pretty much doubled in most of the states. Florida, for example, started with 8 statutory aggravating circumstances. Now we have 16. The idea was that the legislature would come up with aggravating factors and would limit the situations that could call for the death penalty by these aggravating factors that would be applied in a consistent manner. And in that way, there wouldn't be a problem with the death penalty. There would be this narrow group, and it would be consistently applied in those situations. Justice White and Stewart were very concerned that, and pretty much leaning toward a mandatory death penalty, because you probably remember the line that Justice Stewart had about to be struck by lightning was essentially the chance of being executed with a death sentence. And what we found, though, is states, one by one, when there is a politically charged case, the legislature the following year tends to add another statutory aggravating factor. And so the notion that the aggravating factors that the court accepted in 1976 in Gregg and in Jurek and in Prophet versus Florida, they would actually narrow who would get the death penalty and there would be some consistency, has really been shown not to be the case. I think my home state of Florida is probably the best example in terms of our arbitrariness that I've witnessed. I mentioned we were the first to reenact the death penalty after Furman. The statute we enacted limited the jury's discretion to, as I said, 8 statutory aggravating factors and 7 mitigating factors. The jury came back with a recommendation that was not binding on the judge. The recommendation was by majority vote. It was the only verdict, by the way, in Florida that did not have to be unanimous. And trial judges routinely were overruling the jury verdict, whether it was life or death. In fact, to prove the extreme, there were 2 defendants who were actually executed despite the fact that their jurors voted 12-0 that a life sentence was appropriate. Buford White and Bernard Bolander. The interesting thing as well is that both men were sentenced by the same judge. In July of 1978, the Supreme Court decided Lockett versus Ohio that there had to be individualized sentencing and mitigation had to be unlimited to anything that was relevant had to be considered. As I mentioned, Florida had 7 statutory mitigating factors. So we knew at that point that our statute was unconstitutional. But our court, after that decision, said, well, the statute really doesn't limit mitigation. And executions continued. Years later, the court decided Hitchcock versus Douglas, and that was 1987, so almost 10 years passed. A unanimous court, with a decision written by Justice Scalia, who was new to the court, held that the Florida system had unconstitutionally limited the jury's consideration of mitigation. At that point, Florida had already executed 16 prisoners for whom the mitigation had been limited. All of whose executions were under an unconstitutional statute. So the importance of timing was clear. Then in June 24, 2002, the Supreme Court decided the case of Ring versus Arizona, which held that under the Sixth Amendment, the jury had to make the findings that enabled enhancement of a sentence. In Florida, we had 2 men who were under death warrants, and their death sentences were stayed pending the decision in Ring. However, after the court issued Ring, they, instead of granting certiorari and vacating and remanding for consideration by the Florida Supreme Court, the stays were simply dissolved. And our court took that to mean that the Florida statute survived Ring. And Amos King and Lenore Bottas were executed. It wasn't until March of 2015 that the court granted certiorari in Hearst versus Florida and finally addressed and held that Ring does in fact apply and the Florida statute did not comply. That our juries, as I mentioned, just gave a recommendation. There were no findings. It was not binding on the judge. And the statute then had to be reenacted. There was a lot of argument about whether we should go to 9 votes for death being required, 10 votes for death being required. They settled on 10, but months later, our Florida Supreme Court held that under the 8th Amendment, a unanimous jury was required. So when we look at the numbers, when we talk about the significance of where the prisoners have fallen under a timeline, we see that prior to Hitchcock, we had 19 executed. Between Ring and Hitchcock, Ring and Hearst, we had, let's see the exact number. It was somewhere in the 40s, I believe. And what we then had with the Hearst decision was 383 prisoners on death row. The court had to decide what to do with those prisoners. And they decided a new retroactivity principle. They divided the prisoners between those whose cases were final prior to the Ring decision, not Hearst, and those who came after the Ring decision. 19 prisoners lost because they had waived the advisory jury. 40 lost because their jury came back with a 12-0 recommendation, mind you, under a totally different system. And 160 lost because they were on the wrong side of that 2002 line that the court drew with Ring. 157 are going to be resentenced because they were on the right side of that line. I just want to mention that with unanimity, we've now had 31 life verdicts in Florida and only 10 death verdicts. And in 21 cases, these are 21 prisoners who have been on death row for years. The prosecutors have agreed to life sentences, and we anticipate that that number is going to be growing.
Thank you very much, Karen. I think that you were now America that arbitrary patterns like accidents and timing, of course, knowing that they haven't got to decide what you have to decide, but choosing not to decide, not to decide, makes it realizing very believed by everyone who lived with it. And she has some other examples of that.
I hope so. I hope I'll get a program project. I'm going to tell you, I have about, in a semester, I have about 6 weeks of material right here in 10 minutes. So get ready, be busy. What I'm going to do is I'm talking very broad strokes about a couple of things which I think are important in thinking about the death penalty today. So I do want to talk a little bit about this idea of unconstitutional executions. Karen has referred to those, and I want to talk a little bit about the Texas experience with that. Talk about why we may currently be in a moment where there are people whose execution we very well may find to be unconstitutional in the future. We should be concerned about a category of people who are susceptible to execution now. And then I want to begin our conversation about the unreliability of the system as a whole, some of the problems the system has in really administering justice as the Supreme Court itself anticipates will be done. So that's kind of my mission, unconstitutional executions and unreliable systems. So one of the ways in which Texas can is consistent with the Florida experience is that Texas also has had, since the inception of the modern death penalty, 1976, it had a jury instruction for death penalty cases that was subsequently found to be unconstitutionally constrained. So Texas juries would have to answer the question, was the murder committed deliberately? And is this person a continuing threat to society? Is this person a future danger? So this goes along undisturbed as the central question until 1991, the statute is changed and there's subsequent important litigation that happens after that. But there is a large category of people who are sentenced to death in Texas whose jurors could not give meaning to conditions conditions they might have that would be both mitigating, but also make them dangerous in the future. For instance, one might think that someone who has a serious brain injury that affects their impulse control, but they may well be dangerous. They can't control their impulses as well as someone with a fully healthy brain. But it's not their fault that they have a brain injury because they grew up in a toxic environment full of environmental poisons, or their mother hit them in the head with a frying pan when they were 3 years old. We want to consider those people differently from your cold, calculating, deliberate murder, right? That the court is trying to come up with ways of thinking about people differently and recognize that some people may be more dangerous, but we want to show them mercy. And the Texas system did not permit that to happen. And so there were certainly scores of people. I don't have the numbers right with me. You got to go to the fantastic Death Penalty Information Center database for that. But there are, it's a complicated story, which is one reason why I don't have the number, but who would have these claims, who was executed, and what happened within a certain period of time. But certainly a substantial number of people who were sentenced under an unconstitutional statute and who were executed. So Texas certainly tells us there are people who've been unconstitutionally executed, but I also want to talk to you about some of the categories that are emerging that people are talking about, and where we're seeing action in there are two in particular. One involved people with serious mental illness, and the other involved the people who are under 21. Just to give you a little bit of the legal framework for this, the court is concerned about excessive punishment. The Eighth Amendment prohibits excessive punishment. Punishment must be proportionate to the crime and to the culpability of the individual, and the court has a test within this Eighth Amendment framework of trying to figure that out. So it looks at what are, the standard is not what punishments were available when the Constitution was drafted. It's right now. What are our evolving standards of human dignity? What do we do now to punish people? And so the court will look at legislative enactments, look at jury verdicts. It will look at a range of information to see what do people think now about imposing this kind of punishment for somebody who's done it. So that's one part, that's sort of the objective factors that it considers. It also considers independent judgment and thinking, does executing this person further retribution or deterrence, the two stated justifications for the death penalty? So, for instance, when we talk about this proportionality review with people with intellectual disability, what we used to call mental retardation, the court surveyed the legislative landscape and counted the number of states that had prohibited execution of people with intellectual disability or mental retardation. It also then, in sort of bringing its independent judgment to bear, it thought about what it means to live with intellectual disability. Talks about how intellectual disability can interfere with your ability to understand and process information, to control your impulses, engage in logical thinking. Talks about the fact that often people with intellectual disability, they tend in groups to be followers rather than leaders. They are less likely to be the cold, calculated killers. And this diminishes their moral culpability. They did something terrible, but they're less morally culpable. They can be punished under a criminal justice system, but they're less morally culpable. And they're also more likely to get the death penalty. They're less likely to help their lawyer. They're likely to confess falsely. They're more likely, they're less likely to be good witnesses, either as they sit at a counsel table and jurors observe them or on the stand. So they are disadvantaged because of something that's really not their fault. So that was the court's decision in Atkins versus Virginia in 2002, where it said people with intellectual disability cannot be subjected to the death penalty. The court takes another step in a case called Roper versus Simmons in 2005, saying people under the age of 18 cannot be subjected to the death penalty. Why is that? It traces the same outlines of the Atkins argument. The court also points to to the immaturity and irresponsibility of youth, their vulnerability to negative influences, and their more malleable character. The idea, right, that they can, they have lives where there can be real turning points to come away from where they've been. They have, as the court said, a greater claim than adults to be forgiven. And coming back to our point about unconstitutional convictions, before Roper, 22 people who were juveniles at the time they committed their crime were executed before them. So we have this template of intellectual disability and of juveniles. And so where's the ABA right now? So the ABA, along with every other significant professional association involving mental illness, has adopted a resolution barring death sentencing and execution of people with severe mental illness. Now, as Karen referred to, there are protections for people who are actually insane, right, actually delusional at the time of their execution. Whether those procedures are as effective as we would like is one question, but there is some layer of protection for people who are actively hallucinating or delusional, in the grip of the delusional system when they are on the verge of being executed. So what the ABA is coming into is a space which is looking at people who are suffering from severe mental illness at the time of the offense. It's very narrow. It's a very cautious resolution. Some people would say one must have a severe mental disorder or disability that significantly impairs the individual's capacity to appreciate the nature, consequence, or wrongfulness of their conduct, to exercise rational judgment in relation to conduct, or to conform their conduct to the requirements of law. Some of you may remember from law school, if not your actual current practices, a lot of it sounds like different insanity tests. So in that way, this itself is not a very broad exclusion that they're calling for. But the idea is that everything we talk about in the context of ethics is true with this population as well. In the sense of often being less able to control impulses, less able to understand consequences, poor witnesses, poor assistance to their counsel. This is certainly, it is inarguable that there are individuals who are very mentally ill, who have very severe mental illness at the time of their offenses. And one high-profile example is that of Scott Kennedy out of Texas, and we can certainly talk about his situation, question and answer. I want to spend a moment in week 3 of our syllabus talking about the second resolution before transitioning over to Rob's talk. And then the House of Delegates of the APA adopted the resolution to exclude people with serious mental illness from the death penalty in 2006. This year, in 2018, they adopted a resolution barring the death penalty for people under 21 years old at the time of the offense. This is the so-called Roper extension. And it's the same idea as Roper was capitalizing on advances in brain science that tell us that the human brain is in fact not fully mature until about age 21. There are no cutoffs when it comes to these physiological processes, but 21 is a much better marker for the adult brain than 18. And then also one of the reports for the resolution notes that many states are noting this difference. Many states, whether it's about foster care and increasingly about juvenile jurisdiction, are shifting from 18 to 21 in recognition of that. All right, so the last couple of points I want to make involve some aspects of unreliability in the system overall. One is, I just told you about categorical exclusions, and I think the idea there is it makes our system fairer to exclude certain categories of people from the death penalty. But just because the court says something doesn't make it so, and there are significant difficulties in enforcing these categorical exclusions. We have to ask, do these categorical exclusions work? And a recent the state of Texas case, one of which went to the Supreme Court, demonstrates some of the problems, at least with the intellectual disability exclusion. There are three essential criteria of intellectual disability. One involves IQ testing, 70 or below, roundabouts, we can talk about that. Onset needs to be before 18. And then there's this idea of adaptive functioning. How do you do in the world? Are you able to essentially live independently and meet your social responsibilities? When you ask people about this, questions will involve, can you make change for $1? How do you catch a bus? Can you tell me how to get to your job? How do you know how to catch a paycheck? Do you know how to cook food for yourself? And these are questions which can be suggestive of adaptive deficits. So the Supreme Court had referred to different standards from professional psychological organizations about intellectual disability, but in Texas does what Texas does, and it identified language in advocates that said, we leave to the states the task of developing appropriate ways to enforce constitutional restrictions of under-execution sentences. It left the states the discretion to define what intellectual disability was. So Texas did that by including in the analysis questions that are not appropriate to intellectual disability. Does the person respond coherently, rationally, and on point to oral and written questions, or do his responses wander from subject to subject? That may be a very pertinent question when talking about someone with a psychiatric disturbance and illness, but it's not really fitting someone with an intellectual disability. So the court developed these restating factors, and in one case involving Bobby Moore, who went to the court said, no, you really can't just make up stuff. You really need to tether the definition of intellectual disability to what professional experts say about it, and indicated that the APA, the American Psychological Association standards, should inform the views of the court. Mr. Moore, having won in the Supreme Court, is returned to the Texas court, which again found he did not have intellectual disability, in part because he has learned how to read during his period of incarceration, and he can use the prison commissary, which is probably not necessarily the best indicator of adaptive functioning, but that's a story for another day. Very quickly now, volunteers, Karen mentioned, volunteers, another source of unreliability in our death penalty system. Volunteers are people who actively seek their own execution. They say, please kill me now, sooner rather than later. It's a concern that constitutes about 10% of our system, the number of people executed. 10% about of the people executed in this country have volunteered for execution. Their demographics track people with who are at high risk for suicide anyway, which we can talk about. But for our purposes, which is a reliability question, what's happening when people say, execute me? They're saying, execute me without judicial review of my trial and of my sentence. That alone disturbs our confidence that the death penalty is uniformly applied, and that we are, in fact, executing the worst of the worst. In one case, the study, a man said, please don't put, I refuse to allow mitigation to be presented in my case, because I live with hallucinations all the time, and it just makes my life torture. And the only way I can think to make it end is to die. And so I would like to be executed. And so the court said he understood the consequences of waiving his appeal, so he could make a competent decision to waive his appeal, and he was thereafter executed. You can see why there may have been a constitutional claim that could have been raised under those circumstances. Mr. Swift should not have been executed. My last point, I just want to build on what Karen said about race and racism infusing the death penalty, because the death penalty is part of the criminal justice more broadly. Karen said McCluskey is certainly a low point in trying to have the court grapple with the implications of empirical data. It rejects these very powerful findings that, in Georgia at least, race was as powerful an aggravating factor as a prior murder conviction, right? And that none of this mattered because the court was going to focus on what was happening in individual cases. Batson challenges the concern about jury bias in affecting racial bias affecting juries. It's also something the court itself has recognized that our system of keeping racially biased jurors off juries is not very effectual. And so we can talk about that at the end. And the last point I want to make is one of the concerns I have when I see the Supreme Court take up these race cases is that many of us think that is fantastic. The court is finally paying attention to the effect of race in the system. But I think it has a paradoxical effect because while it is great to have the court reaffirm our commitment to race-neutral justice, in fact, in many ways, it takes exceptionally aggravated cases that very few people will be able to take advantage of the rule that the court is propounding. It becomes much easier for lower courts to say, well, you didn't in fact have an expert on the stand saying people of Latino men are particularly prone to violence. You didn't have that particular constellation of aggravating facts, and so therefore you don't get the benefit of the rule. With that, I'm going to stop now. We'll reserve for later, but I want to turn it over to Rob.
The question is, has death penalty become an act? For that, we need to know a little bit about history. So I'm going to talk pretty quickly about evolution, at least in public opinion and in law, and whether the evolution of public opinion against death penalty, reduction in use of death penalty, has resulted in the death penalty that is less arbitrary or one that remains arbitrary. And are we actually executing people in a manner that's constitutional and right, or are the people who are being executed the most vulnerable as opposed to the most deserving of death? Now, when we look at the history of death penalty, recent history of death penalty, in the United States in the mid-1990s and late 1990s, 80% of the American public, according to Gallup, supported the death penalty. The latest Gallup poll is at an historic low. It's less than 55% support the death penalty. And when we look at the numbers from the Pew Research Center, it goes from 78% in the mid-1990s down to 55% today. So whatever we're seeing, it is a huge shift. It's either 30 percentage points under Gallup or 25 percentage points under Pew, but it's a consistent move in one direction, away from the death penalty. So the United States, across every demographic group, substantially supports the death penalty less than it did in the 1990s. Along with that change in public opinion, we're seeing changes in what's actually happening in the courts. And so when it comes to new death sentences, we're going from 315 death sentences imposed in 1996. That's 315 death sentences in a single year in the United States to 35 last year, 35 2 years ago, 39 last year. I think that while the numbers may go up and down a little bit in the near future, you're never going to see numbers like we saw in the 1990s. And that's because public opinion has shifted away from capital punishment. There have been a number of reforms in the system in various different states, like having institutional capital punishers who know what they're doing. Council makes a huge difference. In a city like Philadelphia, my hometown, there have been 85 death sentences imposed since 1993. And of those 85, 1993 is significant because that's the first year the Philadelphia Public Defender was created to handle capital cases. They get 20% of cases. The council made no difference. They have 16 death sentences. Not one single public defender client has ever been sentenced to death. So council makes a difference. And the evolution in the way in which defense representation has been handled has made a huge difference across the country. Death sentences have plummeted in Texas. They've plummeted in Georgia. They've plummeted in Virginia and North Carolina, these traditional big death penalty states. The death penalty disappeared in New York because after the Capital Defender's Office was created, there wasn't a single capital defender client who got sentenced to death. And one of the factors in the elimination of the death penalty in New Jersey was that there was meaningful capital representation provided. And so with the erratic sentences that were imposed being overturned in the courts, there basically was a huge waste of money. When you provided adequate representation, people didn't get sentenced to death. And so when we look at where death sentences are imposed right now, we can tell you that when there are a lot of death sentences imposed, you can bet that there are a constellation of criminal justice issues, over-aggressive prosecutors, lack of adequate defense services, and more. So we're looking at a long-term decline in the death penalty, and the question is, are people being sentenced to death now, since there are 1/10 as many? Are they more morally culpable than this huge number of people who are being sentenced to death in the 1990s? And all the data indicates that they are not. The same factors apply. A recent study in Tennessee looked at 2,500 first-degree murder convictions, found that you could not tell by looking at the nature of the murder whether somebody would get the death penalty or not. What you could tell is factors like geography, what side of the bridge the murder was committed, factors like the political ideology of the prosecutor, factors like the quality of defense representation, and disturbingly, continuing factors about the race of the defendant and the race of the victim. Those were the primary determinants of whether the death penalty was going to be imposed. So the death penalty is on the decline, but it is just as arbitrary, just as capricious as it was in the United States declared it unconstitutional in 1972. And when we look at what's going on, the social conditions now may be right for the United States Supreme Court to step in, except that the composition of the court is much different. Since 2015, we look back on the decade preceding 2015, and for every year afterwards, there have been fewer death sentences imposed over the course of that decade than in the 10 years that led up to the United States Supreme Court declaring the death penalty unconstitutional. It's not just a national decline, it's a nationwide decline. The decline occurs in virtually every jurisdiction, and in particular in the jurisdictions that have over-pursued the death penalty, gotten many death sentences in the past. And just for folks who are listening remotely and people who are here, we are going to be uploading a whole range of slides that will illustrate the decline in the death sentences across the United States. You can take a look at that for yourself. Now, this evolution, this concept that the death penalty evolves, and that what is the appropriate thing to do with the death penalty changes over time as society's values mature, that is something that is not just unique to the law in the United States. And it's not just unique to the law. The Cardinal will be talking about that as well when it comes to the attitudes of the church. But it's also the case that evolving standards of decency are governing international death penalty practices. So one of my former clients, a gentleman by the name of Roger Judge, had been sent from Canada to the United States to face the death penalty. And he raised a challenge in the United Nations Committee on Human Rights. And in his case, the UN Committee adopted new international law that says because the international values have changed, it is no longer appropriate for a country that has abolished the death penalty to send somebody in their possession to a country that has the death penalty unless they obtain assurances that the death penalty will not be carried out. So that's one of the core principles of international law, and it's part of this whole doctrine about the law evolving as society matures, as public attitudes change, locally, regionally, nationally, internationally. The law is supposed to change with it. And historically, each time there's been a change, it's been a change against the use of the death penalty or in limiting the use of the death penalty. Well, what happens in the places that aren't limiting the use of the death penalty? And what happens, how is it that the death penalty is still in operation in the United States? One of the disturbing things that we discovered in the 2013 study is the non-disturbing part is almost nobody uses the death penalty in the United States. The disturbing part is that 2% of the counties in the United States produce 56% of all the death sentences and more than 50% of all the executions. 80% of the counties in the United States have nobody on the record. 85% have never executed anybody. But there are these tiny clusters of counties that are responsible disproportionately for sending people to death row, with disproportionate moral costs for all of us, disproportionate economic costs for all of us, and disproportionate opportunity costs because of all of the judicial resources that get sucked into capital cases. The question then is, what can be done about it? That's something, I think it's a discussion for another day, but that's something we really have to think about. What I would suggest is people do not over-pursue the death penalty. Counties do not over-pursue the death penalty and be fair in everything else they do. It's kind of a canary for bad conduct. And so if you see this kind of overproduction of the most punitive sanction, I will bet you that you will find a whole constellation of other social justice issues. Every place we look, you see that. And so if you want reasonable criminal justice reform, you can look to where there's no reduction of death penalty. That would be a red flag for where we need to institute reforms across the country. Last year, just 3 counties accounted for 31% of all the death sentences imposed in this country. It's an astonishing number. And as we look at where these things happen, there's now a cluster in the southwest corner of the United States, 5 Southern California counties, Las Vegas, Clark County, Maricopa County, Joe, Ohio, Phoenix. Those 7 counties in that area now account on a regular basis for a quarter of all the death sentences that are imposed in the entire United States. Even more disturbingly, the death penalties that are being imposed now are even more racially disproportionate than they were in the past. We always knew that there was some form of racial disproportionality going on. And the hope is that as the death penalty is pursued less, you get rid of the arbitrary factors like race. In fact, the opposite is happening. So when you get rid of the death penalties on the edges, they tend to be death sentences imposed on white defendants. They tend to be death sentences imposed when the victim is a victim of color. And so we're getting even greater concentration of death sentences imposed on white victims, and even greater concentration of death sentences imposed on victims of color. Executions are at near historic lows. The last 3 years are the lowest rate in a generation. That's including this year. We're going to stay close to that level, maybe a little bit higher than last year, but it's still going to be near historic lows. But are the people who are being executed the worst of the worst? It's still more with white victims. It's still more with defendants of color. What is even more disturbing, I think, is when we look at what are the characteristics of people who are being executed. Are we executing people who can genuinely be considered the worst? And by any objective answer, any objective measure, the answer is no. Frank Baumgartner, a researcher at the University of North Carolina, took a look at all the executions this century and came to the conclusion that the death penalty actually targets people who are mentally ill. Now, that doesn't mean you go out and you search for somebody mentally ill and you seek them out and you impose death penalty. But the way the system works, as it pulls people out of the system, those who are least able to fend for themselves, most vulnerable, are the ones who get through. And so it turns out that a hugely disproportionate number of people who are mentally ill are the ones who are being executed, despite the fact that 2/3 of Americans oppose the use of the death penalty for people with mental illness. And another illustration from last year, more than 85% of the 23 prisoners executed last year showed evidence of significant trauma, mental illness, brain impairment. The most vulnerable, not the worst of the worst. More than 200 people have been executed in the United States in circumstances in which they would never be eligible for the death penalty today. We've talked about some of them. 43 intellectually disabled people were executed before the acting decision made it unconstitutional. 20 people were executed under Texas's unconstitutional scheme of determining intellectual disability. People continue to be executed under Georgia's scheme of requiring defendants to prove beyond a reasonable doubt that they have intellectual disability. 22 prisoners under age 18 were executed before the United States Supreme Court said you could not do it. 23 people were executed in Florida under the Hitchcock scheme, when the state unconstitutionally limited what could be presented in mitigating evidence. 90 people have been executed in Texas because of the improper way that statute was written, making it so that the jury could not give meaningful effect to mitigating evidence, or when the court created this limitation saying the mitigating evidence had to be related to the circumstances of the offense. And it goes on, and it goes on, and it goes on. 11 people under the Ring decision that was mentioned. And Florida, looking forward, has already made judicial decisions that, if carried out, will guarantee that 150 or more people will be executed, despite the admission by the Florida courts themselves that the death sentences were unconstitutionally imposed. You add to that the 10% of all the people who were executed were volunteers. We can have no sense of reliability in those cases. They waive judicial review. And there's the ultimate problem, which is innocence. For every 9 people who've been executed in the United States, 1 has been exonerated. And we know at least a dozen, and probably significantly more, innocent people have been executed in the United States since the 1970s. So we've got a problem. We've got a very serious problem. We want the courts to be able to handle it. And the last thing I'll say before I turn this over is the courts are not doing a very good job. I'll give you one example, and it's going to be inflammatory, and I'm actually not going to apologize for that, because I think it accurately illustrates how broken the system can be. A very recent study done in Harris County, Houston, Texas, the county that has executed more people than any other county in the United States, and more than any other state except for the whole of Texas itself. A recent study showed that in 95% of the cases in Harris County where there were contested issues of fact, the Harris County courts literally adopted the prosecutor's fact-finding verbatim, word for word, many times including proposed facts, many times including mistakes of fact, and mistakes of law, and typos and misspellings. And that has consequences, because when the state court issues a fact-finding under the amendments to the federal habeas corpus statute, the federal courts are bound to those fact findings. And that means with its rubber stamping in state court, which goes far beyond Harris County, there is no meaningful federal judicial oversight. It is, and this is what's inflammatory, as if the prosecutor were the ventriloquist, the judge were the dummy, and the federal courts were the audience pretending not to see the list. That is not reliable. That is not the way we would want if we're going to ever have it that way, these cases to be resolved. And that, along with all these other factors, highlights why, if the death penalty hasn't become an anachronism, it has become an unreliable disgrace.
Thank you. Before I turn it over to the coroner, I want to make one other observation. As mentioned before, that the Supreme Court in 1976, in Gregg and other cases, upheld the new death penalty statutes. Subsequent to that, of the justices that upheld the new death penalty statutes, Justice Blackmun said he would no longer be party to the machinery of death, came out completely against it. Justice Powell went on to write the infamous McCluskey decision upholding racial discrimination in death penalties, said that was the worst decision he ever took part in, not because he disagreed with the part about race, but because we should have gotten rid of the death penalty. Justice John Paul Stevens came out against the death penalty and said that had he still been alive, Potter Stewart, who was also in that plurality, would not have voted, had he known how the Supreme Court would allow these procedural technicalities to overcome justice, and he would not have had his vote either. When you combine that with the people of the dissent, an overwhelming number of those who were on the court in 1976, which allowed the death penalty to come back, had they known what was going to happen afterwards, would never have ruled that way. But that is not what happened. So now we turn to the perspective of the cardinal, and we have a concern over it. Yes.
Well, first of all, I'm really grateful to be here, especially with such distinguished professors and attorneys who have studied this problem. They really have put us in touch with the systemic injustices that are involved in the application of the death penalty in our country. And so that's why I'm very glad that the media here, because I hope that this really will be a story that's covered by our local media to bring home the difficulties that are involved in having the death penalty in our country, and the statistics that we have just heard are so chilling that it should make everyone sit up and think about what we're doing in this country. As you may have heard, Pope Francis made a bit of news today in revising the catechism of the Catholic Church to say that capital punishment is inadmissible because it is an attack on the inviolability and the dignity of the human person. That this dignity persists, the revision continues, even after the commission of very serious crimes. Adding this language to the catechism, the Pope has made official the development of church teaching that gained steam under Pope John Paul II, who repeatedly described capital punishment as virtually never acceptable and called for an end to state-sanctioned executions the world over. And this development was carried on by his successor, Benedict XVI, and now today the magisterium, that is the teaching office of the church, affirms the doctrine, the moral doctrine against capital punishment. And the fact that the church, quote, works with determination for its abolition worldwide, as Pope Francis said in the revision in the catechism today. For close observers, the Holy Father, this development does not come as a surprise. He has consistently called for the abolition of the death penalty, and he did early on in his papacy at a meeting with representatives of the International Association of Penal Law in the summer of 2014. At that time, he referred to a penal populism that promises to solve society's problems by punishing crime instead of pursuing social justice. He admitted that according to the Catechism of the Catholic Church, the traditional teaching of the Church does not exclude recourse to the death penalty, if this is the only possible way of effectively defending human lives against the unjust aggressor. But as the Catechism has long emphasized, he noted that modern advances in protecting society from dangerous criminals mean that cases in which the execution of the offender is an absolute necessity are indeed very rare, if not practically non-existent. Now, in the discussions leading up to today's meeting, I was told that the advocates of the so-called doctrine of evolving standards of decency were intrigued by what Pope Francis said in that 2017 address about the development of church teaching. I imagine that they are even more intrigued today. On that occasion, in 2017, the Pope observed that in the Catholic view, tradition is a living reality, as the Word of God cannot be mumbled, as we heard earlier, like some old blanket, in an attempt to keep insects at bay. Rather, it is a dynamic and it is a living reality that develops and that grows. While I'm not confident enough, nor foolish enough, to enter the debate about the Constitution being a living document, I do want to say something about two important principles developed at the Second Vatican Council that have forced the Church to come to this understanding of its position against the death penalty. Doing so will allow me to give a philosophical or theoretical understanding or grounding to the evidence of the inequality and inconsistency that others have pointed out here this afternoon. So the first principle has to do with how the Church, not to mention how every Christian, should understand its role in the world, in the modern world. We have entered, the Second Vatican Council noted, quote, a new stage of human history, the birth of a new humanism, where people are defined first of all by their responsibilities to their brothers and sisters and to history. As a result, the proper task of the church and each Christian is to work with everyone in building a more human world. In a word, Catholicism as religion cannot be understood without a social commitment, to the point that salvation and the efforts toward transforming history are intertwined precisely because God has set out to make people holy and save them, not as individuals without bonds or links between one another, but to bring them together as one people. God's work, which truly must be our own, is about bringing people together toward a more profound level of human intercommunion and shared life. And so we have to do all that we can to make sure that no one is excluded. And we are especially to be attentive to those who live at the margins of society, the poor, the vulnerable, the weak, those whose lives are at risk, including those on death row. Simply because God's plan is to bring people together and to make sure that no one is left behind. That's the first principle in which we base our teaching about the death penalty. The second one has to do with the dignity of the human person and the inalienable right to life, which Pope Francis emphasized in his decision to revise the Church's teaching in the Catechism. The Church has long held that the dignity of the human person is rooted in his or her creation in the image and the likeness of God. While this principle is often called upon by the pro-life movement, it has not been so prevalent in the death penalty discussion, that is, until today. Almost a dozen years ago, when I was the bishop of Rapid City, South Dakota, a much smaller place, by the way, than the Archdiocese of Chicago, I pointed this particular point out in an article that I wrote for American Magazine. I simply asked the question, is a right to life unconditional in all circumstances, or can it be forfeited by criminal behavior or advancing age? Now, the occasion for writing this article was the coincidence that voters and the legislature of South Dakota were simultaneously considering the issues of abortion and capital punishment. A law banning all abortions except to save a mother's life was up for vote. Proponents forcefully argued that the right to life is universal and that it's God-given, a position that's held by the Catholic Church. The statute they supported did not refer to degrees or graduations of the right to life, nor did it rest on an individual's quality of life, their age, or their moral worth. At the same time, lawmakers were attempting to clarify the state death penalty statute, as it was discovered that the lethal injection drugs ready for the execution of a convicted murderer did not conform to state law. Now, members of both houses rushed to announce their intention to fix what they called the cocktail problem, so that the death penalty could proceed. Now, I fully realize that the moral weight of these two issues differs greatly. Abortion, after all, involves the taking of an innocent human life. It occurred to me that the convergence of these debates on abortion and the death penalty provided an opportunity to reflect more deeply on this claim that the right to life is universal and God-given and unconditional. I argued that the assertion that every human life has an inherent and inalienable value will only be strengthened if we apply this principle to the morality of defending both convicted criminals and the lives of the unborn. As I noted, the death penalty confronts us with a penetrating moral question. Can even the monstrous crimes of those who are condemned to death and are truly guilty of such crimes erase their sacred dignity as human beings and their intrinsic right to life? Despite today's news, I know that faithful Catholics will continue to struggle with this very question. And it is not hard to understand why. There are, after all, impulses deep in the human heart that answer, yes, certain crimes do bring forfeiture of human dignity. That response springs from compassion for the victims of the most barbarous crimes in society, but also a desire to restore the order of justice that has been so viciously violated. At a profound human level, we tend to believe that by executing a murder, we are somehow helping rebalance the scales of justice. But I argue this is a very flawed view. It is a flaw in the way of thinking. For the real tragedy of murder is that there is no way to rebalance the scales of justice, no way to bring back life to those who have been killed or restore them to their grieving families. When the state imposes a death penalty, it proclaims that taking human life counterbalances the taking of another life. And this is profoundly mistaken. If there is any lesson we need to learn in this perilous age, it is that taking a human life in the name of retribution does not bring justice, and it doesn't bring closure, even if it may feel that way in the particular moment. Rather, capital punishment only continues the cycle of violence and vengeance. The tragic truth is that nothing can restore a human life. We are left confronting the unavoidable moral question posed by capital punishment. Is the right to life conditioned, or is it unconditional? Can men and women forfeit their right to life by their behavior, or is that right irrevocably given by God? Can society, that is we, the people, determine that the crimes committed by human beings supersede their intrinsic claim to life? This question is all the more trenchant in an age when secure prisons and viable justice systems can virtually guarantee that those who have committed the most grievous acts against their fellow citizens not pose a continuous danger to society. It means that when the state endorses or chooses to perform executions when there are other ways to protect society, it is concluded that the right to life is conditioned after all. Such a state, even if it does not intend to do so, inevitably weakens the ability of its citizens to defend the sacredness of human life against all threats that imperil life in the present day. Erasing the innate value of individual lives because of crimes committed and removing such criminals from the human family is an echo, in my view, of the violence done to human dignity when pro-choice advocates imply that the life developing in the womb is not really human. Both conclusions assume that the right to life is contingent, rooted not in the free and absolute gift of a sovereign and loving God, but in the discernment of relative worth by society. On the other hand, a state that rejects in principle the execution of even those individuals whose crimes are unspeakable bears powerful witness to the unconditional nature of the right to life. It asserts that every member of the human community shares a dignity that is not canceled by defects of health, age, or morality. A state that refuses to use the death penalty advances a culture of life with great power of witness, precisely because it protects the lives of those who have been judged least worthy of its vindication. The Church, and now Pope Francis, consider how this question bears on all issues related to human dignity. We live in an era when the dignity of human life is threatened. Wherever we turn, we encounter mounting efforts to treat the lives of men and women as mere means to larger and allegedly more important goals. Global markets are developing for the sale of vital human organs by those driven in the desperation of poverty to risk death in order to provide food and shelter for their families, In our own land, a dominant culture ethic asserts that the lives of immigrants are of less value because they are other, they're alien. The same ethic avows that unborn children have no sanctity when weighed against the wishes and the needs of their pregnant mothers, and that those in declining health are less worthy of continued care. And in terrorism, we see the chilling assertion that it is legitimate to kill innocent men and women in the service of political goals, religion, and revenge. This is why it is so vital for us to have this discussion, and especially for us to urge all elected officials and leaders to recognize their responsibility, but also their vested interest, the vested interest of society in defending the sacredness and the value of every human life. This principle of the dignity of human life has to underpin any reference that we make here today to inequality, inconsistency, and systemic injustices. It is it holds together a care for the poor, weak, the migrant, the excluded. Our assertion that the value of human life does not depend upon an individual's quality of life or age or moral worth must apply in all cases. For if we protect the sanctity of life for the least worthy among us, we surely witness to the need to protect the lives of those who are the most innocent and the most vulnerable.
Thank you very, very much. I did want to ask a question which you know that I was going to ask, which I think is particularly relevant given that Justice Scalia is now as the model of a paradigm of a Supreme Court justice. And in a talk that he actually gave here in Chicago, that we have put on our section's website, along with the post talk, he, after going through an historical commentary about the role of kings and the death penalty and things like this, he got to this point. And reading it in some ways, not too much. As we think about it, he says, so it is no accident, I think, that the modern view of the death penalty is important. It's centered in the West. That has little to do with the fact that the West has a Christian tradition, and everything to do with the fact that the West is the home of democracy. Indeed, it seems to me that the more Christian a country is, the less likely it is to regard the death penalty as immoral. Abolition has taken its firmest hold in post-Christian Europe and has least support in the church-going United States. I attribute that to the fact that, for the believing Christian, death is no big deal. Intentionally killing an innocent person is a big deal. It is a grave sin, which causes one to lose his soul. But losing this life in exchange for the next, the Christian attitude is reflected in the words Robert Colt's play as Robert Thomas More saying to the headsman, "Friend, be not afraid of your office. You sent me to God." And when Cranmer asks whether he is sure of that, Moore replies, he will not refuse one who is so blessed to go to him. For the non-believer, on the other hand, to deprive a man of his life is to end his existence. What a horrible act. And I was wondering what the reaction is to that.
Would that he had lived to be here today to see what the Pope has done, because I think it would not be cause to rethink that. I think that his understanding of salvation has great limitations. It's an atomistic view of salvation, that is, as individuals. What I said in my first point is that, as what the Second Vatican Council has brought to our attention, is that God saves the people. God doesn't just save by individuals. And so how is it that we integrate human beings into society, especially those who are at the margins? That's the question we should be posing here. yes, it's true that we all who are in the Christian faith believe in an afterlife and the immortal gift of life that God will give us. But as we live our life here today, our task is not just to think about me in terms of my own salvation, personal salvation, but how is it that I'm working to create a people where everyone feels that they're included. So I think he misses that point, and he has a narrow view of what salvation means in Christian tradition.
Thank you. I think now I would like to see if any of the panelists, any of you have any questions that you'd like to raise with each other, or any points that you wanted to make earlier. This may be most true of some of the people on the table that I cut off, that you didn't get to make before, but now that we still have more time, that you'd like to make now.
Could I just put a little context to this moment in which I wrote that article?
Yes.
Because I think it helps summarize some of the things. The case with regard to this cocktail problem involved a murder of a young man who was severely tortured and beaten by 3 people. And it was clear that they were guilty of this crime. There were 3 of them. The youngest one was a young man who was lived in a family with a mother who was a prostitute, who put him out for prostitution at a very young age. He was physically and sexually abused when he was very young. Grew up, was in and out of school, foster care, and all the rest of it. He got in with these other 2 old guys, and he was around 20 years old. They were older. And he decided to go with the judge, and they went to a trial with the jury. He got the death penalty, and even though he was the lead of the 3 responsible, and the other 2 got life imprisonment, he wanted to die. His life was so terrible. And so as I spoke out about this, I said, what we have here is not the death penalty. We have state-assisted suicide. That's what's involved here. So just to give what you said really validated, or at least spoke to some of the experiences that I have here. That those kinds of things happen more often than we think. And it's a story that we're not telling in society we're talking about. And shame on us.
I agree with your comment, because I think that when we talk about 10% of people executed having volunteered for the call for this, I think it really understates the number of people who may have given up at earlier points and which becomes invisible from the legal process, but it's something that is really a struggle for lawyers for far more than 10% of the people who have been sentenced to death, and that it is it's also it really brings forward that this is not a solution for dealing with the tremendous homelessness and depression and other struggles that people have with them.
It's interesting when we have legal ethics discussions about lawyers who death row inmates, and everyone else involved with the head of the ADA death penalty representation practice well aware of this. One of the questions is, what do you do when your client, who you are convinced is mentally ill, and it's the mental illness talking, is insisting on dropping all the appeals and getting in? And that comes up all the time. Rob, you look like you want to say something.
Yeah, having represented a number of volunteers, one of the things that you discover is that for almost every person who's on death row, they've been failed by one authority figure after another for much of their lives. The amount of physical abuse, sexual abuse, neglect, abandonment is unfathomable. And I think the single most ubiquitous feature of the lives of people who are on death row who are actually guilty is that they have experienced extreme and chronic trauma throughout their lives. Some are more resilient than others, but the ones who are the least resilient are even more vulnerable And what we've seen with the volunteers is that they have largely been abandoned. They received very little assistance as they were coming to trial, or they're so far along the path to suicide that they're beyond the assistance of a lawyer who is competent to properly represent them. And they face a court system that is extraordinarily poor at addressing issues of mental illness. As a result of that, you have people like Scott Panetti, who dresses up in a purple cowboy suit with delusions and is permitted to represent himself. You have other people who are not so flamingly crazy, who are able to articulate what appears to be a reasoned basis for ending their lives. But when you get beneath the surface, you realize that it really is suicide. And the question is, if we're going to have the death penalty, if you accept that as even a possibility, shouldn't it be limited to circumstances in which you can assure that it's reliable? Shouldn't it be done in accordance with law, not in violation of the law? If state assisted suicide, if suicide at all is illegal, why should we be facilitating it just because we want the person to be dead? Why not let the other legal sanctions govern? And I find this to be profoundly disturbing, because my goal when I was representing people who were on death row was to preserve their dignity and to give them a voice that they had never had before, and to try to get the court to see them as a vulnerable human being who never should have been put to death in the first place. And our allowing this whole concept of volunteers to be executed to go forward flies in the face of all of that. We're also distorting the process. We can see the two worst cases of that right now are in the context of lethal injection. So Carrie D. Moore, who faces execution next week in Nebraska, and Scott Dozier, who faced execution last month in Nevada, neither one of them has had any meaningful judicial review of their cases, and both of them volunteered to be executed. And the prosecution and the courts have, for the most part, been complicit in that. And that I say with trepidation, because these are people that we depend upon to enforce the law and for the dignity of the law. But they seem to have, in this instance, decided that it's better to get an execution done quickly than to have a meaningful review of the illegal activities the states have been going through in trying to get execution drops. There's a state interest in ensuring that if we're going to have the death penalty, states don't violate the law in order to carry out the law. But yet, in both Nebraska and in Nevada, there is significant evidence that state actors lied to drug manufacturers and drug distributors. And so the medicines that were, according to the manufacturers and distributors thought were going to be used to cure people who were sick, stockpiled them so they wouldn't be used in medical services at the risk of public health, and got them in violation of contracts. They took these controlled substances that could be sold only for medical purposes and converted them from medical uses to executions. And we should not be violating the law to carry out the law. And these volunteers are making it impossible for the courts to address those issues.
I was just going to say, we can talk to each other pretty easily if people have questions. If you have questions.
If you don't, I can have some. Does anybody wish to ask a question that I can repeat at the microphone? Yes.
Question for the Cardinal. First of all, greetings from Spokane.
Greetings from Spokane.
Good.
We miss you.
Thank you.
There has been a lot of attention in the media about how a huge amount of support for the death penalty in America exists in the American South. And in particular, that is rooted, sincerely rooted, in their belief that is consistent with Old Testament or attributed teaching. And I wondered if the U.S. Council of Bishops or any other progressive religious organizations in this country have reached out to the religious leaders in the South.
Not to my knowledge, but I would think that the development today might be the impetus for introducing that topic in the ongoing ecumenical dialogue that we have. And I would say that also with the Muslim community, because I think that in many Islamic countries, they still have the death penalty. And I don't know enough about their own teaching to be able to say whether or not it's justifiable in their teaching. But if in fact there are those strains within text, whether the Hebrew Scriptures or the Quran, that would lead people to that conclusion, then I think it would be important dialogue about that. So I guess that's where I would begin to have that discussion. But I think that it should be introduced into the ongoing ecumenical dialogue that we have already.
Let me add something to that, because back in 2001, I organized a program at Central Synagogue in New York City, which is available online, and one of the two origins there are at Law Religion. And it was about law, religion, and death penalty, and we in particular brought in a Talmudic scholar to go through the particular so-called Old Testament passages that supposedly justify death penalty. And while we did not conclude that the God in the Old Testament always came out against the use of the death penalty, places where there was have never been implemented, like the Bible, things like that. And the example of a quote from the Noah story is totally taken out of context as it's explained there, and was also noted by a Protestant minister who gave a sermon that day, that the first murder in the Bible, Cain against Abel, resulted in a mark of Cain that was put on to prevent Cain from being killed in retaliation. And the fact is that in the Jewish Bible, which is part of the Christian Old Testament, they made it virtually impossible to have a death penalty imposed because they required that before a capital crime was committed, two eyewitnesses had to come up to the people's back to commit the crime and say, do you know that if you go out and commit this crime and we see it happen, you can then get executed? Now you can imagine how few times that actually happened. It was usually thrown out by the Sanhedrin. And they said that a Sanhedrin that ever upheld the death penalty maybe once every 7 years would be, according to Hillel, a bloody Sanhedrin. In the state of Israel, whatever else one may think about it, the only death penalty they up to now have had for anything is crimes against humanity that was imposed once against Abel Beckman. So I think that we tell that, and the reason why I thought this program needed to be organized, because I have been very dismayed over many years by well-meaning Christian opponents of the death penalty saying, oh, the God in the Bible supposes love the death penalty, vicious and horrible God, but Jesus got it all correct in the New Testament. I have more faith in both Jesus and God in the what Christians call the Old Testament, have faith in what they both said, and to come out with a conclusion that is consistent with what the Pope said. Yes.
Well, and just to elaborate on that again, I would say that I'm struck by the parallel between the view of the Pope and the view of rabbinic Judaism in terms of the word not being lawful but evolving with time. Because, as you were hang around with the rabbis or rabbinical interpretation basically made it impossible to apply the capital punishment to any of the various things that was supposed to be applied to the Bible.
I hope that the board will take that comment, but you know, I know you said it, and we can get it to you. But the point of the matter is that when I read the fourth wall talk about the cardinal, another reason that it struck me, in addition to its parallel to the legal doctrine involving standards of decency, is to the development of Judaism and particularly the spirit of Reformism, but also Orthodox Judaism, which do not take things as static and thinking that because we want to believe something 2,000 years ago, we have to believe in it exactly the same way today. Are there any other questions?
Business of interpretation of scriptures, for instance, which is part of the development of teaching. There was a document written under his yield when Benedict XVI was head of this office called the Congregation for Doctrine of Faith. And he, in that document, the whole approach of fundamentalism was taken on. And at that time, Benedict called it intellectual suicide. In fact, it would be so fundamental that you look at things so literally without any sense of hermeneutic by which you can interpret the scripture, then you really are turning out the brain. And that doesn't seem to be what God created this for.
Yeah, we've spoken a lot about this portion of minorities who are on death row. I'm wondering if there are any promising solutions to address this issue, because in the criminal justice system is a huge problem. I'd love to hear some thoughts about what can be done to address it.
The question is about whether anything can be done to address the disproportionality of people of color.
That's a difficult question to answer because the death penalty, when we look at the problems with the death penalty, the magnification of all the other problems at every stage of the judicial process. And I think that we have really significant race issues at every stage of the process. So if you look at what happened, I think there's certain, the shortest way to eliminate race discrimination, capital punishment, is not have capital punishment. That's self-fulfilling prophecy. But when we look at start from even before the charging practice, we look at policing practices. Policing practices disproportionately arrest people of color for offenses that white people are not arrested for, or arrested less frequently. So you have disproportionate arrests. From the disproportionate arrests, statistically, there's evidence of disproportionate charging. It's a little bit more concentrated. From charging to the time of trial, the question of who gets most adversely affected by poverty and poor indigent defense services. Defendants of color are more adversely affected by that. And then once you get into the courtroom, when you're looking at examples, instances of prosecutorial misconduct or instances of jury's behavior, you see the prosecutorial misconduct is more frequent with defendants of color, and you see that juries on the same set of evidence view it differently with respect to white defendants than they do defendants of color. So discrimination gets concentrated each step along the way, and unless you address the social issue head on, you're not going to eliminate that problem from capital punishment.
I just wanted to add on that, I really liked your way of talking about the overproduction of the death penalty as being symptomatic of a pathological criminal justice system. And I think that it goes, the problems of the death penalty and racial disparities go hand in hand with other types of racial disparities in the criminal justice system. And one of the really dismaying parts of McCluskey, the case we refer I've become convinced that maybe the most important actors in the system are prosecutors, or district attorneys, or state attorneys. I think having real conversations with district attorneys, political actors, about what they're running on, what their goals are, what they think are criminal problems, or what do they think are social problems that we should meet in non-criminal ways. And what are they going to do about policing? What are they going to do about, they have tremendous authority, literally, but also sort of moral and political capital. What are they going to do about race problems in their jurisdiction? And I think that electing conscious DAs is one of the most important things that we can do. That's my 2 cents.
We found that in Florida, well, one of the largest counties for producing death sentences for some years has been Duval County, home of Jacksonville, Florida. And a lot of that was attributed to the state attorney at the time, who we would say didn't ever see a first-degree murder that wasn't worthy of a death sentence. And there was a concerted effort, and in some large part, people are pressing that the prosecutors needed to address this issue. And ultimately, Angela Corey, the state attorney, has been replaced by a prosecutor who spoke to the problems with the justice system and what the racism that had really plagued Duval County in the past. And we're seeing differences now coming out of that county finally.
I think Karen and Meredith nailed it with those 2 things, and these statistics actually verify that. The 16 counties that produce the most death sentences in the United States over the past years, prosecutors have been defeated in 6 by reform candidates. The fact that's most likely to significantly change the rate of death sentences in the county is change murder rates, change in the prosecutor. So if you do treat the death penalty as sort of canary for criminal justice reform, or if you just go about electing prosecutors who are interested in criminal justice reform and fairness, that will significantly reduce the usage of the death penalty overall, and while it won't eliminate race discrimination, it will reduce the number of people who are discriminated against. The one scary thing that I see is that in Houston and Philadelphia, the 2 biggest death-producing counties in recent times, who have had reform prosecutors, the rates of death sentencing plummeted in both of them, and the racial concentration of death row increased.
I would just add that one interesting sign or something are 2 opinions written by Chief Justice John Roberts. One in the buckets that was talked about where there was sort of spoken out about that the defense experts said that the defendant was more dangerous because he was personally color. And the other, I believe, correct me if I'm wrong, was Foster, in which they got the actual notes of the prosecutors who deliberately challenged with their discretionary strikes blacks from juries in Georgia. And they were found to be that they had this clear evidence. And in both cases, Chief Justice Roberts said, we will not count this in our criminal justice system discrimination on the basis of race. And that sounded really good in isolation. And if you take what the court has done so far, you have to say, now does this mean that they no longer believe in custody? Or do they only not believe in custody if you have somehow the ability to find hidden documents, hidden objections, hidden motivations, and or having blatantly, not unconsciously racist, but consciously racist witness. And it remains to be seen because the logic of what the Chief Justice has said and the words couldn't be more different than what Justice Powell said in McCluskey. But time will tell, now that he appears to be about to become the swing justice of the Supreme Court, what our limits are on this view that he expressed in his two pieces.
It also seems to me that if you're going to be clear about the influence of race, not just in the court, you also have to see what impact it has had in the whole process that brought this person to this situation. So it's insufficient for a justice or the court to say, well, this is going to be racially kind of a pure process without looking at what were the relative value in which racism was a very important factor in the person even getting to this moment in their life. I think you can't so segment racism within that moment in court. You have to take all of that into consideration.
I'm amazed at the perceptiveness of the cardinal that analysis, because the cardinal has not even gone to the death penalty training program, at which it is taught that you have to know the whole history of lynchings and community and drama, and the effectiveness of that and how it continues on to this day. And it's remarkable memorial that's just over a few months ago in Montgomery to all the victims of lynching, and the death penalty was justified in some of these places as a more genteel replacement of lynching. And Brian Stevenson, who was behind what they've done in Montgomery, is, I just learned yesterday, receiving the Indian medal on Saturday, which all deserves it, but it is wonderful that even assuming that you didn't go to the kind of training about this, that you have this wonderful perception, which we are hoping that even defense lawyers, for example, is one of the difficulties that we have had over many years is that many of the people with the most unconscious racism and the least ability to expose the very factors in the background of their offense are their own counsel. And that is something that the guidelines for counsel were running against and striving against, but that was a serious issue when I'm glad you nailed that one on the head also. Okay. And the other comments? If not, I want to thank everybody for your participation in this program. Assuming that we did get an audible recording of this program, we are going to have it transcribed. We will speak and in Rob's wonderful slides that you get to see and get published at least online and maybe in a word. Thank you all very much.
Yeah, I'm just.